We are live.
Hi guys.
Hello, welcome to the podcast. I'm John.
And I'm Hayley.
And we are the Speed Mooting team.
And this is the Speed Mooting Partners in Crime podcast.
That it is. Big news this week, Hayley.
Big news this week.
Big news. Hayley.
I wasn't sure what news it was. I was like, what's the news, John?
Do you know what news I'm about to announce?
I do.
Okay. We have not one, but two winners in the Speed Mooting team now. Mm-hmm. So Hayley is the Altaris Young Businesswoman of the Year.
Whee!
Congratulations.
Shall I get my trophy?
Get your trophy. Let's see it.
Here it is, in all its glory.
Look at that. Just move it a bit left, Hayley, just so you don't... There we go. I can see it now. Oh, look at that. Altaris Women in Business Awards. Young Businesswoman of the Year. Global award winner.
Global, guys.
Global.
We've gone global.
We've gone global. You are the Global Young Businesswoman of the Year.
I guess I am.
Yeah.
I guess I am. There we go.
There we go.
Boom. I'll just put it there for the whole episode. No, I'm kidding. That'd be funny.
Yeah, so, well done. Congratulations, Hayley.
Thank you very much.
Just over 12 months at the JPD group here with the Speed Mooting team. You're smashing it.
We're doing all right, aren't we?
We are doing all right.
We are doing all right.
Changing the world, one mooting competition at a time.
Indeed.
But yeah, so congratulations. Well done.
Thank you.
That leads me on to... Well, it doesn't really lead me on to, but I'm going to go
You're going to lead on to it anyway.
I'm going to name the episode.
Okay.
Episode 61. It's been 6 episodes since we've actually had a Formula 1 driver number. Mm. But we're back. We're back. So Carlos Sainz, if you remember, episode 55 was our last one. Mm. Today, we are on episode 61. Today's number is a temporary number, actually. So the driver, he did have... So this was a temporary number that he used for the 2024 Abu Dhabi Grand Prix. He did run with a different number in Formula 1, which I'm just checking. He took Kimi Räikkönen's number, because once a driver leaves F1 after 2 years, their number can be reused by someone else. So he's never actually had an episode yet. So it's not the end of the world that he's getting this one.
Okay.
On his temporary number. So
am I going to be able to guess him?
Let me give you some clues. He is from Australia. Mm. Yeah, I had to check that. So he's from Australia. Drove this season for Alpine. Unfortunately was replaced in the last race, so unfortunately for him anyway. So he's been replaced by Franco Colapinto.
No. I only know the main ones, from the main teams.
His dad was some sort of world champion on a motorbike. Probably not going to
No, go on.
It's not Valentino Rossi's son.
Okay.
I don't even
just about to say that.
I don't even know if Valentino Rossi has a son, but yeah, it's Jack Doohan.
No.
Okay. So Jack Doohan. Incidentally, his first go-kart when he was 3 years old, do you know who gave it to him?
Michael Schumacher?
Yeah.
Oh, really? Jesus.
Yeah, he was neighbours with Michael Schumacher, and that was his Christmas gift.
Wow.
I mean, imagine getting that imagine like my next door neighbour giving you a Christmas gift that good.
Well, I'm guessing if he was neighbours with Michael Schumacher, he comes from money, so probably was just another gift to him.
Yeah, probably. It's like, oh.
It's not like Michael Schumacher being our neighbour, is it? Like, come on. Yeah.
Oh, you didn't even get me the Evo engine. It's just a basic Rotax Max. Take it back, mate. So that's when that's your first Christmas gift, I think you're onto a decent. You
got a good life ahead of you, haven't you?
Yeah.
You haven't got many problems.
No.
Okay, so
so welcome to episode 61, the Jack Doohan special.
Welcome.
Do you know what? We haven't said much about him. In fairness, he was a good driver. I thought it's just F1's cutthroat at the minute. You're not getting any time whatsoever, and no time to bed in, so we got 7, maybe 6 races and then hit the chop. But, who knows? We're seeing people bounce back all the time, so we might see him back in F1, you never know.
Watch this space. So before we get on to our usual content, obviously most of our listeners will know, and even if this is your first time tuning in, hopefully you can tell by the accents that you are listening to a couple of Scousers.
Yeah.
Born and bred in Liverpool, and it's the 28th of May when we're recording this episode, so we thought it was only right that we do mention the incident that happened in Liverpool this weekend.
Yeah.
I'm sure you all know what happened. Very briefly, we had the parade for Liverpool Football Club. It was supposed to be a massive day of celebration for the city, and it took a very dire turn when somebody drove through the crowds and injured a lot of people. Very fortunately, we don't know anybody who was injured. A couple of my nephews were supposed to be there, but for various reasons didn't go, which I'm very grateful of. But yeah, I think there's 11 people left in hospital at the last update I heard. I think they're all stable now.
Oh, that's good.
Which is, great news. But yeah, we just wanted to say that as a small business that exists right in the heart of Liverpool, our thoughts are with everyone that was injured and with everyone that's been affected by this, because it must have been horrendous to see and to be there. So we are thinking of you all, but as I said on my LinkedIn post, we're a strong, proud city.
That we are.
And just as we come together to celebrate the good times, like the sheer numbers that were out in the rain to watch the parade demonstrates, we come together in the bad times as well. So we'll get through this. So
yeah, absolutely. Apparently there were over 1 million people there.
Yeah.
Yeah. So
from all over the world.
Yeah, absolutely. So it's just a shame that as you say, what should have been a good day took a turn like that. So thoughts are with everyone, and we hope everyone makes a recovery.
Yeah, absolutely.
Yeah.
Right, back on to some more cheerful topics, like some criminal law.
Nothing to cheer you up like a bit of criminal law.
Exactly.
So last night we had the legal section of the Advocacy Club, and it was all about the plea mitigation. Quite aptly timed, given that we've got the Plea Mitigation Competition next month. So, so it was a good session. I enjoyed it, and it was all about the plea mitigation, as I say. So, our members got to put forward a plea mitigation on behalf of somebody that had entered a guilty plea nice and early. And so what we do is, the way the Advocacy Club works, people practice the piece of advocacy in small breakout rooms. It's low pressure, you get feedback from your peers, and then at the end of the session, I bring everyone back, I give some general feedback, and then open it up to questions. And we actually overran by about 5 minutes, and we had to sort of cut the questions off, didn't we? So we've had a fair few questions come through, which I thought, well, do you know what? Let's open it up to the Ask Speed Squad session.
Indeed.
Ooh, that was a mouthful. And let's answer some questions.
Cool. So this is basically a plea mitigation special.
Pretty much, yeah.
Let's go.
Let's go. So, fire some questions at me, Hayley.
Are you ready?
That was very, very Triple H of you there, wasn't it?
Yeah, it's supposed to be.
Yeah. I'm ready.
Before we dive in, because this is a plea mitigation special, for our listeners that are like, what on earth is plea mitigation? Do you want to just give a very quick intro?
Let's explain what it is. So the plea mitigation is something that's presented at a sentencing hearing. So a plea mitigation is done when somebody either pleads guilty to an offence or they've been convicted at trial. So long and short, they need to be sentenced. So the defence advocate, whether it's a barrister or a solicitor, will present an argument to the judge to try and obtain, or magistrates in the magistrates court, to try and obtain the best possible outcome for their client. So what they're trying to do is outline the mitigating factors, address the sentencing guidelines, and ultimately get the best possible outcome.
Okay.
Yeah.
Boom. First question.
Yes.
Do we need to consider factual mitigation and personal mitigation separately? I think before you answer, you probably need to explain again what the two different things are.
Okay, so the question's asking about factual and personal mitigation. So factual mitigation is anything to do with the facts of the offence itself. So, for example, taking an assault, you might say, well, this was a slap by comparison to a shod foot, that was used. So you're saying, it's in the grand scheme of things a lot less, so that's factual mitigation that brings it down. In the scenario that we had last night, it was about someone that was driving whilst disqualified, and you might say, well, the individual in this case was saying, they were desperate for money, they'd lost the licence, they only ever knew how to do driving jobs, so that's part of the reason that they were doing the offence. It could be, let's say you've got, some sort of large-scale conspiracy involving multiple people, and you say your guy was lower down in the organisation, they weren't a key figure in the organisation of whatever it might be, whether it's a drugs conspiracy, whether it's a conspiracy to commit nuisance, whatever it might be. So that's your factual mitigation, anything that relates to the facts and why the offence was committed.
Yeah.
Okay. Personal mitigation is mitigation that, generally speaking, doesn't really relate to the offence itself, but it's just mitigation relating to your client. So it could be the fact that they've never been in trouble before, it could be the fact that they've always had jobs, they're a hard-working individual, they've got children, if they go to prison, who knows what's going to happen to their children, anything like that, anything that relates to the person themselves.
Yeah. Okay,
so that's the difference in the two. Now, I think where this question comes from is I gave a general structure for a plea mitigation. And, I say this all the time, there's no one size fits all, everyone's got their own approach. But as a very general, this is a good structure, go with this. And, I use this often, don't use it all the time because, I deal with every case on a case-by-case basis, and sometimes I want to deal with things in a different order, but a decent structure is deal first with credit. So, has your client pleaded guilty, and if so, at what stage? Because they get credit for that, and no doubt we'll talk about credit at some point. Remorse, if they've pleaded guilty, are they remorseful? Point that out. Then factual mitigation, so why did they commit the offence, and any way you can take the sting out of the offence itself. Personal mitigation, so everything relating to the person themselves. Then go through if there's a pre-sentence report, and no doubt we'll talk about a pre-sentence report, but if that exists, talk about that. Then deal with the guidelines, and away you go. So I think where this question is coming from is the fact that I've separated factual and personal mitigation. That's where this question stems from. Now, sometimes the factual and the personal can overlap. So, for example, in this particular scenario, you've got an individual, he's recently been disqualified for drink driving, he's then driving again, and he's undertaking, a delivery job or something like that, I think a couple of weeks after he's been disqualified. And what he says is, well, the reason that he was doing this is because he was desperate for money, he wanted to get onto a course, he needed to build up some money before he goes on this course, he's only ever undertaken driving jobs, he's got no qualifications whatsoever, dropped out of school, all the rest of it, so probably would find it difficult to find alternative employment that quickly. So that was part of the reason he was doing this. And that goes towards your factual mitigation, because A, it shows why he committed the offence, but also it's personal mitigation as well, because it goes to his circumstances. So sometimes there's a bit of an overlap. And the point being, if you're following that structure that I'm talking about, sometimes, a piece of mitigation that you're going to present can go to both, and you can mention it in terms of factual mitigation and then develop it later on when you come on to your personal. But yeah, it's the structure I've given is a general overview. Sometimes there's things it could overlap, so pick where you're going to put it.
Yeah.
In. Okay. I hope that answer makes sense.
I think it does. Next question. If there are aggravating factors on the facts, can we simply address them and explain why they are insignificant and have no effect on the starting point, or will they always have an effect on the starting point if they exist on the facts? Okay,
so what we're talking about here is, we're talking about the sentencing guidelines. So within the guidelines, so let me bring up the guidelines for this particular offence. So just bear with me a moment while I bring them up. Mm-hmm. So the offence in this case was driving whilst disqualified, and you've got 3 categories for offending. So this was a category 1 offence. So the way the guideline works for category 1, you have a starting point of 12 weeks custody, and then a range of a high-level community order through to 26 weeks custody. So what the range means is that's the range within which the judge can sentence, and your starting point of 12 weeks is where the judge starts. So you start there, and then you look at the aggravating and mitigating factors, and that moves you up and down within the range.
Yeah.
And normally what a judge will do is they'll say, well, I'll take this starting point, I look at the aggravating factors, which moves you up to here. Taking into the account the mitigating factors, that brings you down to wherever. It might be below the starting point, might be at, or it might be above the starting point, and then you apply credit and look at any personal mitigation, etc. But in terms of the starting point, that doesn't really move. So you take your starting point, then you apply your aggravating factors, which moves you up. So the aggravating factors don't change the starting point. The starting point is the starting point. It's the aggravating factors that then move you up.
Yeah.
Okay. That's the way in which you would deal with that. So sorry, just repeat the question again.
If there are aggravating factors on the facts, can we simply address them and explain why they are insignificant and have no effect on the starting point? Or will they always have an effect on the starting point if they exist on the facts?
So as I say, they shouldn't really affect the starting point. So the starting point is what the starting point is. The aggravating factors then may move you up. So what you might want to do is you might say, whilst I accept that there are, X, Y, and Z aggravating factors, the mitigating factors, which I've already outlined, would outweigh those, such that I would invite the court to either come to the start, if that's what you're saying, you want it to go to the starting point, or if you're saying mitigating factors outweigh the aggravating factors, you might say, well, that will bring us down below the starting point, or I'd invite you to come below the starting point. So, as I say, what the judge is doing is starting at the starting point, looking at the aggravating factors, which might move you up, and then the mitigating factors might bring you back down.
Yeah.
So if you're trying to, I wouldn't say they're insignificant. I think that because you're downplaying the offence. What you might say is you might want to use a phrase as, whilst I'm by no means downplaying this offence, the mitigating factors will outweigh the aggravating factors because, or you'd say, the aggravating factors are so small that they wouldn't attract an uplift within the guidelines themselves.
Great.
Yeah. Hope that answers the question.
I think it does. I think you're doing it very well, John. Do we have to consider the information from different parts of the bundle separately in our structure?
Okay, so the question there it relates to the Advocacy Club, where you receive a bundle, and within the bundle you'll have the prosecution's case, the way they work, the prosecution opened the case, the pre-sentence report, and then there's written instructions from your client. So it's as if you've met the client in conference, they've given you instructions. So do you consider them for different points? Well, no, I think you're taking them all together. So, the bulk of the personal mitigation, for example, will come from different sources, the pre-sentence report, and of course the instructions from your client. Any aggravating factors, particularly relating to the offence itself, will naturally come from the prosecution case, what they've said, the case summary, etc. But of course, there might be something that your client tells you from the instructions that takes away from that. So, no, you're not looking at them in isolation. The different elements, if I put it that way, of the plea mitigation, you'll find, your submissions will come from different parts of, the bundle, as it were.
Great. Is there likely to be judicial intervention in the competition?
Okay, so this is a question about our plea mitigation competition next month. And no, there's no judicial intervention.
Boom. Will you significantly lose points if you use a script and your eyes switch back and forth once in a while?
All depends on your judge, but if you are literally glued to a script in a competition,
if I was judging you, you would lose points.
Yeah. Because there's a difference in a competition and, in practice. Because what you'd probably find is, in practice, you meet your client, you take some notes, and then you go into court, and then, you'll glance down at your notes, that point, okay, yeah, you look up and you flesh out the point. In a competition like this, obviously, you've got time to practice. So, if you are literally glued to a script, I suspect you probably would lose points for that, because you're not going to have much rapport with the judge. And a plea mitigation is all about being persuasive, it's all about having rapport. So I would advise practicing such that you wouldn't be tied to a script.
Yeah, if your competitors have managed to learn it without a script, or, you know, aren't note tied to a script, because it's okay having some bullet points to help you and stuff if you need them, isn't it? But if they're not note tied and they're engaged with the judge, and it's so much easier to be persuasive and empathetic if you're not reading from notes, they're going to progress over you if you are note tied.
Yeah.
Can you refer to the defendant as my client, or is it better to refer to their name?
Either or. I tend to refer to them by name, you know, Mr. Smith, Mrs. Jones, whatever. It brings them to life.
I was just going to say, it humanises them, doesn't it, when you're trying to, you know, make someone understand them.
Yeah.
Empathise with them, rather than just my client, you know, it's a nameless person. I mean, it's a bit different in real life because they'll be there, wouldn't they? They could see them, but I think by, you know, giving them a name, gives them the human element to make sure they know what this is an actual person that I'm thinking about.
Absolutely.
So I would say name over just saying my client.
Yeah, that's it. And, you know, just a sort of a linked point is, you know, sometimes let's say if, you know, they've got a family member in court, you know, it might be their mum, the dad, whatever, and, you know, you're going to be referring to them at some point in the plea mitigation. So say, for example, it's, you know, they've lost their way a little bit, and then the mum's there saying, oh, well, he's going to live with me now, I'm looking after him. You know, you might say, when I refer to that part of my plea mitigation, I will turn around and say, well, his mum is at the back of court. She is now going to be provided with accommodation, which should allay any fears about X, Y, and Z. So I think just any way that you can bring it to life always helps a plea mitigation.
Yeah. Is the point in most examples of a plea mitigation not to challenge the categorisations advanced by the prosecution, but rather to argue for the minimum within the threshold?
Classic lawyer answer, it depends. So, you know, look at where the prosecution pitch it. So sometimes I'm jumping between fictional scenarios here and real life practice. So more often than not in the Crown Court, you'll have a written sentencing opening, which means basically it's almost like a script of what the prosecutor is going to say, but you'll know where they're pitching it on the guidelines, so you can prepare for that anyway. But in any event, you will know where you think it falls on the guidelines. So you'll have looked at culpability, you look at harm, and you know where you say it falls. If the prosecutor submits something differently to you, well, no, fight your corner, stand up and say, well, no, this is more appropriate a category 2 than a category 1 because, you know, whatever. Having said that, there will be scenarios whereby, you know, you're on all fours with the prosecutor, and probably in a lot of cases there will, you know, because we're all lawyers, we all know how the guidelines work, so quite often there won't be a dispute about it. And in those scenarios, then you are trying to just bring it down within the category itself. And it's about being sensible. So, for example, on a case like this was one that probably did cross the custody threshold. And your job in reality, you're not fighting the categorisation. You're trying to persuade the judge to give a suspended sentence. So, you know, so it's just think about what the outcome is and what your job is. But no, absolutely don't roll over on categorisation if the prosecutor says something that you genuinely disagree with. So if they've said something and you're in disagreement with it, fight your corner and tell the judge why it should be in the appropriate category that you think.
There we go. So there's a couple more questions now, but these are all about our upcoming competition.
Oh, okay. All right.
So what will be the structure of the competition?
Okay.
I'll answer them all because you're probably going to answer them all within your one answer.
Yeah.
So what will be the structure of the competition? How many rounds do we speak for? Do we go 1 versus 1 and then each winner passes to the next round?
Okay. So the structure of the competition, we have 200 people entering the competition. So it's all on Zoom, and we'll have 20 groups of 10 individuals. Okay. So group 1, group 2, group 3, etc., all the way through to group 10. What happens is each group has its own judge or panel of judges, and let's say you're in group 1, for example. So you've got 10 competitors in that group 1. One by one, you all go into the breakout room with your judge, present your plea mitigation, come out, the next person goes in. No one's presenting in front of each other, so it's just you and the judge in there. Once the judge has seen all 10 competitors, they decide who the winner is, and therefore the winner from each group progresses to round 2. So out of your 20 groups, one from each group progresses, so that means you've got 20 people that progress through to round 2. At this point, given we've got 20 people, we're breaking it down into 5 groups of 4. Same format again. Within each group, the 4 people go in one by one with their judge or panel of judges, present the plea mitigation, the judge decides the winner. So then you've got 5 people that progress through to round 3. This time we've got a panel of judges, and one by one the competitors present their plea mitigation, and we have a winner and a runner-up round. So there's no one-on-one, it's all individual, and you're presenting it against the group, as it were. What was the final question?
That was it.
And how
So
many
we go
times,
1 versus 1, and then each winner passes to the next
and how
one.
many times do you present? So 3 times. If you get through to the final, you'll present 3 times.
Boom. So thank you very much to that Advocacy Club member.
Yeah.
You've just gave us a pretty good segment for this podcast.
Absolutely.
So speaking of Advocacy Club, we've got an exciting summer coming up.
We certainly do.
And last year this was really popular, so we thought, why change it? Let's keep the structure the same. So this summer, our members will have the opportunity to go through a full criminal trial.
Yeah.
So across June, July and August, you get to do opening speeches. You get to do witness handling.
You do.
And then you get to do closing speeches.
Yeah.
So live the life of a criminal advocate this summer with the Advocacy Club.
So it's going to be really fun. So we use the same scenario across all 3 months. So that way, you're following it through. It's nice and consistent. And as I mentioned last night, you get a bit of fun because you get to play a witness as well, so you get to do a bit of acting. But it's really good because there's not many opportunities for people to actually undertake any form of trial advocacy. And it all comes back to why I set up the Advocacy Club, because I think about on the bar course you do a bit of advocacy, and then once you're finished, when do you ever get to do any cross-examination again? You don't. So this is the perfect opportunity to do so. So you'll do your opening speech, all your witness handling, then your closing speeches. So some of my favourite pieces of advocacy all in one. There's nothing like a good trial.
And as John said, they follow the same scenario through, but they also are very standalone sessions. So we in fact we didn't used to group them together, did we? So you'd do opening speeches, and then it might be like 3, 4, 5 months before you did the witness handling. So if you're listening thinking, but I can't get to the session in the middle, it doesn't matter. They are standalone. It just so happens that we've grouped them together now. So if you can come to all 3,
brilliant,
you'll recognise the scenario that you're dealing with. So very, very fun. I think I played a witness one year with this scenario, didn't I? And Darren Weir from Kent did as well. So I played, I can't remember.
You were the nosy neighbour,
I was the nosy neighbour, yeah. It was
Yeah.
very, very fun. Very fun.
Yeah.
So that's what's coming up.
And we've got debating next month as well.
And we've got debating next month.
Yeah.
So if you are not a member yet and you want to join, speedmooting.com. All the information is there for you. So join us, and also join our community hub. So this is it? Are we in its 2nd week now, or 3rd?
Yeah, 2 weeks
2
today,
weeks.
isn't it? Yeah.
So if you missed last week's episode, the community hub is a brand new space that we've created. hub.speedmooting.com. So this is where all of the Speed Mooting community, whether you're a member of the Advocacy Club, whether you're taking part in our competitions or you've taken part in the past, or whether you just want to connect with other like-minded aspiring and junior lawyers, it's a place for everyone to connect, talk, ask questions, share ideas. So I think we've got some questions coming up this month. People are talking and sharing experiences with scholarships. We've had some questions from people about work experience. We're dropping resources in there all the time. And we also have some learning elements as well. So there's a lot of free courses for people. There's also some exclusive courses for our Advocacy Club members. And there's a fun gaming element to it as well. So for people that engage a lot, you move up the ranks, so to speak. And when you reach certain levels, there are prizes.
There are. So, at present, I'm actually top of the leaderboard. So, who's going to come and topple me?
I should be top of the leaderboard. I was top of the leaderboard, and then I switched myself to admin, so I can obviously do the admin stuff. And for some reason, when you're admin, you can't be part of the leaderboard anymore.
Oh, no way.
Because I was right at the top.
Yeah, it's devastating.
Yeah, and it's annoying because we didn't make you admin because we just were like, we have a general like Speed Mooting admin, but then my personal account for a variety of reasons needed to have admin rights as well. So John can still game, and I can't game anymore. It's so annoying.
So I might win a mentoring session with you, Hayley, so you can give me some career advice.
Gotcha. Yeah, that'll be fun. But yeah, so the prizes are mentoring sessions with us, advocacy taster sessions, and free entries to our competition. So some good prizes.
Oh, brilliant prizes.
So yeah, if you're not on the hub yet, as I say, hub.speedmooting.com, completely free to join.
Yeah, absolutely.
I think that brings us to the end because I'm excited because we can break our fast now.
Yeah.
We're having a go. So we went to a wedding on Saturday. So this was a wedding of a friend I used to work with back when I worked with the centre near Mitchell, and they got married. So we went to Manchester, didn't we, for that wedding?
We did, yeah.
And we were talking to a couple of other couples there, and one of them have started trying fasting and like were really raving about it. I mean, the fasting they were doing like 48 hours and 24 hours.
It was extreme.
Not even attempting it. But my sister tells me about it as well, the 16-8 fasting. So that's where you don't eat for 16 hours and then you eat in a 8-hour window. So I was curious. We're giving it a little try this week, aren't we?
Yeah, see how it goes.
So we stopped eating at 8 o'clock last night and we can eat now.
That we can. So just gone 12. Well, it's 20 past 12 now, isn't it? So
to be fair, we typically don't eat breakfast. You do sometimes when you're on the road, don't you? So we wouldn't usually be eating before now anyway. It's just the cuppa. I just can't wait to go and have a cuppa.
Yeah, I had breakfast on the road yesterday for the first time in a while.
Yeah.
McDonald's wrap,
A long drive.
Long drive
yesterday.
Yeah.
But anyway, we'll leave it there so we can go break our fast.
Let's do it. Well, I've certainly enjoyed recording this one. Have you enjoyed recording it, Hayley?
I've enjoyed recording it, John.
Hope you've enjoyed listening. If you're still with us at this point, you are one of our real listeners. And I would invite you to pop a comment underneath if you're still listening at this point. The comment this week being...
Breakfast.
Yeah, let's go for it, yeah. Breakfast, and throw us an emoji of something you might eat for breakfast. Yeah. So, that's all from us. Next week, we'll be recording the podcast again, as usual, as we do every week. It's not going to stop, it's like, it's there. But there's going to be a special segment next week. Something that was recorded a while ago, and we're going to slot in. So,
ooh, I know what this is.
It's very interesting, particularly if you've got an interest in mooting, actually, or legal argument generally. Have a listen.
So tune in.
All the best. Cheerio.
Bye guys.
Enjoying our videos? Then we'd be super grateful if you could take a moment and subscribe to our channel.